as always, by First Commonwealth Bank here on AM 1160 WCCS and 101.1 FM. It's time for another installment of Martial Law on this radio program intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information it may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And there's one of those sitting right across the way from me right now. He's Marshall Chriswell. Good morning.
Good morning.
Hey, I have a question for you about something that I know a lot of people encounter on the roadways, and they really don't know what their rights are. And it has to do with motor vehicle violations. What are your rights when you are pulled over for this violation or that, in terms of, say it's a speeding ticket or an illegal turn or something like that, and they have one opinion of what happened, the police officer has another. If we could discuss that a little bit, and what their rights are in terms of the challenging a ticket or a citation of some sort.
Sure. What I would tell clients in that situation is, looking at it prospectively, you certainly don't want to get into an argument with the officer at the scene there.
Courtesy is tantamount, isn't it?
Yeah, absolutely. And that not only is that the right thing to do, because the police officer is obviously just a person who has a job to do, as we all do, and that also that courtesy and cooperative nature can go a long way when it comes to making the argument then in court that your view of the way things happened should prevail. So because whenever you get to a situation where you're going to challenge a ticket for a traffic violation, in Pennsylvania, where you're going to end up is at magisterial district court, and if it's not a serious violation, like a DUI or something like that, you're going to end up dealing with that same police officer, and you, or hopefully your attorney, talking to the officer and telling him your side of the story, and also seeing what opportunity there is to negotiate a withdrawal of the charges or a reduction of charges. And if you've been cooperative and courteous, certainly that helps.
Mm-hmm. It helps at the scene too, because you might get just a written warning because you were polite and understanding of what exactly the situation is, and the officer might, I don't want to say take pity, but he certainly might take that into consideration.
I would think so. Yeah, absolutely. I think it's very important that you don't want to get off on the wrong foot right away, because you never know, the officer may have just been planning on giving you a warning when he walked up to the car. So
it's a good chance for us to discuss, I think, the differences in the levels of law. Summary law violations versus misdemeanors, and then up to the felony level. There are three different levels to be considered there, and for the layman, they might not know the difference. So if you could start with those two lower ones, summary versus misdemeanor.
Sure. A summary offense is an offense that it would never carry any potential jail time. Okay, these are minor offenses. Now, your traffic violations are summary offenses. Things like a lot of times a public drunkenness, a disorderly conduct, things like that. They do have different levels of disorderly conduct, but generally those are summary offenses as well. They're dealt with at the magisterial district court from start to finish. So they generally involve a fine. Okay, and nothing more than that. They're very minor offenses. Anything more than that, you get into a misdemeanor. And misdemeanors are anything that can carry a jail sentence of up to 1 year. Okay, so that's how you really classify misdemeanors. It's classified by what the potential punishment can be, what the potential sentence can be. So misdemeanors, first offense DUI would be a misdemeanor. They're offenses that don't rise to the level of being a felony, but they're more serious than a summary offense. And those are dealt with initially. Misdemeanors and felonies both are dealt with initially at the magisterial district court level. That's where the charges are brought, you're arraigned, and bail is set. If it's a misdemeanor or felony, there's a bond to be set by the district court, and then also if there's going to be a preliminary hearing, the preliminary hearing is held at the magisterial district court as well, and that's where the state, through the prosecutor's office and law enforcement, need to show that they have enough evidence to sustain the charge. Mm-hmm. So the misdemeanor, the first step is going to be there at the magisterial district court, and then it would proceed then, unless a plea agreement was reached or the case was dismissed. It would then proceed to common pleas court to get on the trial schedule. Mm-hmm. And misdemeanors and felonies both take that same procedural route. The difference with felonies, obviously, is they're much more serious. They carry jail time of anywhere from 1 year to life in prison.
When we talk about misdemeanor and felony law, obviously those require legal representation. Is that the same case with a summary traffic or summary violation of any sort? Would you recommend legal representation for someone who has a summary violation?
Absolutely, yes. Now, summary violations, you're not going to be entitled to an attorney as you are with misdemeanors and felonies, but it's important because those summary violations do stay on your record, okay? Mm-hmm. And there are ways, and a good criminal attorney is going to know, what are the ways that we can get these charges reduced or dropped based on the facts of what happened, or based on knowing the law itself and what would qualify you to have a charge reduced, or maybe have a diversionary program. If you're charged with, this is a misdemeanor, but a possession, small amount of marijuana, okay, something like that, mm-hmm. Then there are diversionary programs where you can do some treatment or some community service or a short term of probation, and actually have those charges taken off the record.
Are we talking ARD here?
Well, ARD is a little bit different. That's okay. You go through the process and you plead guilty, and then the ARD program is a little bit more involved. But there are other diversionary programs built into the system. Probation without verdict is one of them. That would be there was no verdict at all, and you would be able to just do a short term of probation. Check in with your probation officer and comply with the terms and things like that, and you can actually have that charge never even placed on your record. Whereas with ARD, it's a little different. You're going through the process. You are the charge is on the record, and then you do things. You comply with a pretty rigorous set of probation and treatment and things like that to get it removed. So it's a little bit. There are different ways to deal with those things. And the point is, a good criminal attorney is going to know the local courts, the local procedures, and the state law that's going to allow you to take full advantage of those things, rather than just walking in there and relying on the court system to help you out, which it normally doesn't.
As an attorney, do you often get calls from people who say, listen, I was at the local college 10 or 15 years ago. I had an underage on my record or some sort of violation on my record that remains there. I'd like to get that off because it's affecting my ability to get a job now that I'm a grown-up, now that I'm a much more mature person and am pursuing employment. But every time I try to go for a job, boom, that pops up and there's a question. Do you get those sorts of calls?
Yeah, I do. I think that is an issue. You've really hit on an issue that is going to be just very consequential for a lot of people moving forward. I think that in the past, I don't know how many years, I don't want to put a number on it, but in recent law enforcement history here, I think you've had a trend over the last generation of more charges being brought and more people being convicted of these summary offenses. Back when it was okay, you're walking down the street and you're stumbling a little bit and you're coming home from the bars. Okay, just get home safely. Go now. There's really a push, and rightfully so. Towards enforcement, I think, and so the point is that there are lots and lots and lots of people who have summary offenses, misdemeanors on their record. And even worse than things like public drunkenness are theft crimes. Okay, someone, you see it all the time. If you look at the police blotter, you guys do the reporting. Somebody's drunk and they go into Sheetz and they pick something up and walk out with it. Who knows if they meant to do it or they forgot that they, that they hadn't paid for it or whatever it is. You get charged with a theft offense. Man, that's a death sentence for employment prospects.
Follows you for the rest of your life
in the future.
If you don't do something.
Yeah, and historically the expungement laws in Pennsylvania have been really draconian. I mean, you really couldn't get a summary offense. I believe, and I'd have to check, but I think it was 10 years. You had to wait for a summary offense. Anything more than a summary offense, you were basically not getting out of it without a governor's pardon.
Oh, yeah.
Okay. So expungement was very, very, very difficult. The legislature in recent years, in recognition of this issue, have taken some steps to not to modernize the law. Because of this, and not necessarily allow more expungements, but they've included, they've passed laws to seal criminal records in some situations. So if you go, and I'd have to look at what I don't want to say something and not be right, but there, you go a period of time without having another charge, and you can actually have that record sealed so that employers can't see it, but it would still show up. For instance, if you were arrested again, it could still show up and be used for sentencing probably, but wouldn't be available to employers or landlords or things that could really affect your day-to-day life as a law-abiding citizen.
So here we are at the end of the segment, and now we've opened up a whole can of worms. Maybe we can get into this a little bit more about what people can do from a legal standpoint and how they can employ an attorney to help them to make up, or maybe not make up, but remedy some of the problems that they've created with their past behaviors.
Yeah, absolutely.
He's Marshall Chriswell. Thanks so much.
Thanks a lot. Have a good day.
It's AM 1160 WCCS 101.1 FM.